And how are you? I'm Advocate Gaurav Kumar Gupta. I am Chartered Accountant and MBA Finance and PhD holder. My project Derivative Market Future Trend Analysis. आज जो है हम सेक्शन 150 सीपीसी के बारे में डिस्कस कर रहे हैं. इनहेरेंट पावर ऑफ कोर्ट, कंप्रोमाइज डिग्री. कंप्रोमाइज डिग्री का मतलब एप्लीकेबिलिटी ऑफ a suit to questions to compromise decree on the ground that is the unlawful is bare. If a suit is bare, can it be said that the party has no right to questions? Party has to not right to questions the compromise decree either on the ground of fraud, misrepresentation. The fraud now alleged by revision petitioner will not come under any one of these three categories. Therefore, the review jurisdiction on the ground of fraud and misrepresentation so far as the compromise is concerned cannot be invoked under order XL 5 XL7 Civil Procedure Code at all. Therefore, the court below committed an error in holding that the only remedy available to the revision petitioner was to file an application for review. The court is not helpless even in case where the compromise has been recorded by the court when fraud has been perpetrated by either of the parties. Thus, it appears to this court that Section 151 of the Civil Procedure Code is the only section that is applicable to such case. Otherwise, the court will have to shut its eye against fraud misrepresentation, which might have vitiated the compromise. Might have vitiated the compromise. Revision against order of lower appellate court. Maintainable. The revision which were admitted on after 1st February 1977 up to 31st July 1978 would continue to be heard by the High Court and would be governed by Section 150 of the Code amended by Central Act of 1976. According to the amendment of 1977 Central Act, the High Court has jurisdictions has here such revisions. In that view of the matter, the present revision would be clearly maintainable. In this case, the impugned order was passed on 23rd March 1977 by the lower appellate court and the revision was admitted on 2/5/1997. Johir versus Mahendra Singh AR 1981 all 46 and 47 1981 all C 47 4074. Appeal converted into revision limitation. If an appeal is treated as a revision application to treatment relates back on the date on which the appeal is filed, this principle would not, however, apply to case in which one proceeding is substantially converted into another by amendment. Otherwise, in such case, the questions will not be merely of a change of from but of substance. There would be a conversion made and not merely a treatment given. A proceeding which is converted into another must be deemed to be a new proceeding filed on the day on which the conversion takes place. Adjournment application on the ground of advocate illness, where the adjournment was refused under the erroneous conception of law, held such order is revisable under Section 150 Clause 6. Amendment of Section 150 was amended by the State of Uttar Pradesh UP Civil Law Act 1973. Conversion of appeal into revision not maintainable. The defendant voluntarily has a trial on the merit before a regular court. The procedure before a regular court is more detailed. Further, the defendant has had another innings on the merit before the lower appellate court. Under the circumstances, this court do not think that this is a fit case where the prayers for conversion of the appeal into revision should be sustained. The appeal cannot be committed into a revision. Order in revision by district judge not revisable by High Court. In the case as maintained here in before the appeal lay for rent control court to the appellate authority who was the subordinate judge and therefore the revisions led to the district judge indeed in it is the indisputed that the respondent has in his case taken resort to all these provisions after the dismissal of the revision by the district judge from the appellate decisions of the subordinate judge who confirmed that the order of the rent control the respondent landlord choose again to go before the High Court under Section 150 of the Code of Civil Procedure. The question is whether the where he is safe in a second revision on to the High Court. The Supreme Court held that he is right. This position is clear if subsection 5 of Section 18 of the Act is read in conjunction with Section 20 of the Act. Subsection Clause 5 of Section 80 clearly stipulates that the decisions of the appellate authority and subject to such decision and order of the rent control shall be final, shall not be liable to be called in questions in any court of law, except as provided in Section 20. By Section 20, revision is provided where the appellate authority is subordinate judge to the district judge. In other case, that is to say, where the appellate authority is district judge to the High Court, the ambit of revisional power are well settled and need not be restated. It is the inconceivable to have two revisions. The scheme of the Act does not warrant such a conclusion. The expression shall be final. Amendment of pleading. Interference by High Court is revision. In the instant case, the trial court has not followed the principle enunciated by the Supreme Court regarding the allowing of refusing to allow an amendment, and this has affected the ultimate decision in the case if only the principles enunciated by the Supreme Court, which have been adverted to earlier, would have been borne in mind by the trial court while the considering the application for amendment, which only seek to remove the ambiguity relating to the subject matter of the suit, which is in the initial stage. There would have been no reason whatsoever for the trial court to reject such amendment. Thus, failure to bear in mind the principle enunciated by the Supreme Court on the subject amendment has affected the ultimate decision. In exercising the jurisdictions, if the court act illegally, that in breach of some provision law with the material irregularity by committing some error or procedure in the course of the trial which is material, and thereby the ultimate decision in the case is affected by the High Court, can interfere with such an order under Section 150 of the CPC. As such, a case falls under Section 150 Clause 1 C of the Civil Procedure Code. Thus, in the instant case, if the order under revision is allowed to stand, it would not only occasion failure of justice, but it would also cause an irreparable injury to the petitioner, against whom it may, by allowing the amendment in questions, no prejudice whatsoever is going to cause to the respondent. Because the suit is at the initial stage, it does not affect any right alleged to have been accrued to the respondent. Analysis of leading to flying collusions. An analysis of Section 150 Civil Procedure Code in the light of the principle elucidated in the decisions of the various High Court and the Supreme Court lead to the flying conclusions that the word case under Section 150 Civil Procedure Code does not always means the whole suit. It is of a very wide import and means any state of fact judicially considered. It is wide enough to include a decisions on any substantial questions in the controversy between the parties affecting their right, even though such order in pass in the trial of the suit. An introductory order deciding a questions of think these kinds as distinguished from purely formal and the incidental order in case decided within the meaning of section 150 civil procedure code. Such an order will be, however, be open the revisions only if the other condition expressly laid down in section 150 are satisfied and the order has resulted and likely to result in such gross injustice, irreparable injury as can't be remedied otherwise than by the exercise of the extraordinary jurisdictions of the High Court at that stage. Order of additional district judge not revisable by district judge. The proposition of additional district judge as it emerged in view of the various provision of the MP Civil Court Act 1958 in not that of a judge of a court subordinate the district court. On the other hand, the her enjoy an equal concurrent jurisdiction and additional district judge not being a court subordinate to the district judge. The district judge can't be revised an order passed by the additional district judge in any case in exercise of his power as a district judge under section 150 115 CPC amendment by the MP Amendment Act acted illegality with material irregularity. Use of the High Court under section 26 clause C has to see whether there is any error of jurisdictions committed by the controller by the appellant authority in passing the order, whether there is any such manifest error of procedure committed by the court as may affect the ultimate decision, resulting in gross injustice. It is only in the context that under section 26 clause 6 the word acted illegally with the material irregularity have been used. Exclusion of evidence holding it inadmissible, although under law the evidence is not inadmissible when such evidence is a matter piece of evidence influencing the court in passing the final order would come within the concept of acted in exercise of jurisdictions illegally and the material irregularity used in section 151 clause C of the Civil Procedure Code. Admissibility of a document. Admissibility of a document for want of registration was not found to be a matter relating to right obligations of the parties. An order passed in respect of it was not held to be a case decided. An order regarding admissions of evidence in appeal was again not found to be a matter relating to right obligation of party in controversy. The questions of admissibility of the document had to be decided by the court. It accordingly fixed a date for evidence in pursuance of the order of the High Court. The order neither amount to case decide nor does not suffer for jurisdiction error. Arbitration Act Section 70, 30, 39. Order making arbitration award. Arbitration Act is self-contained code and it is as in the Act there is no provision for invoking the revisional jurisdictions of this court against the order passed by the lower appellate court. By exercising revisional jurisdictions under any other law, this court cannot interfere with the said judgment of the lower appellate court. Therefore, the present petition is not maintainable either under Para 27 of the Code Administration of Justice Order 1950 under Section 150 Civil Procedure Code. Arbitration Act Section Act application for reference of dispute to arbitrator. Admittable, admittedly, there is no condition mentioned in the advertisement that even on issuing receipt of the earnest money, the tender will be deemed to be accepted. Therefore, merely by issuing receipt on 2012 1986 for the draft of the earnest money of the tender submitted for alleged contract as per advertisement, it could not be presumed that the offer was accepted and it concluded the contract between the party. The earnest money was also refunded on 41 1987. Thus no right could be accrued to refer the matter for arbitrations under Section 8 Arbitration Act 1940. Under the Act and circumstances of the case, There is no error of jurisdictions. The court below have not committed any jurisdiction's illegality, material irregularity in dismissing the application for reference to arbitration. Benefit of Section 30 read with Section 40 of UP Urban Building Regulation of Letting Rent and Evasion Act 1972. So far as this contention is concerned, it should be seen benefit Section 30 read with Section 40 of UP Urban Building Regulation Letting Rent of Evasions Act 1972 can only be extended in appeal revision pending on the date of commencement of the act. In the act's instance case, it has been found that the act become applicable to the accommodation after expiry of 10 years, holding under UP Act number 30 of 1972 sometime in 1977. Claim petition to be treated as revision